Zoning Board of Appeals meeting to order.
Richard Lentz,
Said your name, Mark.
Here.
John Cole,
Here.
Alderman Berkey,
Here.
Richard Adamczewski, Richard Urbanovich.
Okay, let's, Mark, if you want to start here, what we're,
We need approval of the minutes of the zoning board of appeals meeting
Got it.
held January 11th, 2022.
I so move.
those that approve? Those do not? Done.
Then we have the public hearing. Public hearing is hereby given, or public notice is hereby given that the zoning board of appeals of the city of St. Francis will conduct a public hearing in the council chambers of the city of St. Francis Civic Center located at 3400 East Howard Avenue, St. Francis, Wisconsin, on Wednesday, July 13th, 2022, at 6 p.m. The zoning board of appeals will hear the request of MENI LLC to the decision of the zoning administrator to chapter 455-27E4A, required rear yard depth. Buildings 1 story in height require a rear yard depth of 20 feet. The request is to allow a variance to section 455-27E4A to permit a rear yard depth of 10 feet. The property address is 4267 South Packard Avenue, tax key number 555-0016-1000. The legal description is as follows, and it's listed in the public hearing notes.
Okay, now Mark, if you want to start.
Well, it's the public hearing, so you have to ask if there's anyone here wishing to speak on that requested variance of a rear yard setback from 20 feet to 10 feet.
Is there anybody here to discuss from the store? Anybody here? You step up to that table, please, by the microphone. Thank you.
Add your name to the record, please.
Luis Barbosa, architect. I'm Viren Patel. I'm the owner, property owner, business owner. The owner, Byron Patel, has an existing grocery and liquor store at 4267 South Packer Avenue. He sells alcohol and he sells general groceries. What he has in mind is to do an addition towards the west and an existing green space that he has available. It will be a one-story building. The existing requirements for the setback is 20 feet, and what we're able to provide is 11'6" in order to have the space for what we propose. The proposed addition to the west is facing a public alley, and it's a residential area there. And our intention is to mitigate any invasion of privacy or noise. We're suggesting a wood fence 10 feet away from the property line, as well as a line of evergreen trees also. Another deficiency that we have is that the proposed addition requires 17 parking spaces, and we're able to provide 15. Suggested improvement for that is that at the present time, there are several entrance and exits to the property, and what we're proposing, as suggested by the city, is to close 2 driveways, one facing Packer and the other one facing Luneham Street, and that space will add additional green space. The existing building right now has a canopy that's blue and some siding, and the intention of the owner is to remove the blue canopy and provide a new facade by means of new siding and a new feature in the top with cement panels. Another proposed improvement is the removal and replacement of the existing deteriorated asphalt and the installation of new asphalt with the ability to absorb the water within the property line. The proposed addition is mainly to provide a larger variety of groceries. It's not intended to increase the intensity of the sales of alcohol, nor cigarettes or any smoke devices. The proposed addition will not have any openings facing the west, which is where the residential and the public alley is located, nor will it have doors. We're not changing the topography of the existing property. The water continues to divert there. So we're requesting consideration for what we have in mind. I think what we offer are good solutions, not only to improve the site, but to maintain the level of privacy that's there. The owner, Byron Patel, he has, my understanding is a good relationship with the adjacent neighbors. He had some conversations with them, and the ones adjacent to the alley were supportive of his proposal. That's our understanding.
Can I ask you, the proposed building, will it be equal in size to the existing building?
The existing building is 1,362 square feet. No, I'm sorry, 1,275 square feet, and the proposed addition will be almost a similar size, 1,362 square feet.
Did I hear you say it'll be 11 and a half foot off of the alley?
Yes, the zoning,
For the fence?
yes, this, you have the proper line, the alley is to the west, the property line. The zoning code indicates that we need to be 20 feet away from the alley. What we have available is 11'6", and what we're proposing from the property line on the west side towards the back of 10 feet away from the property line is where we will install a suggested wood fence.
Right.
And then in front of that, we will have a line of evergreen trees. In addition, also, there's an existing garbage area on the north side, and the owner also has intentions of removing the existing deteriorated fence, push it closer towards the northwest corner, and provide a loading and unloading area within the premises.
Rick, if I could interrupt 1 second. Paul, if you had a,
Yeah,
what was,
thank you.
what did you want to make clear?
Surely, I just wanted to clarify at the outset. So this is a request for an area variance. And by statute, because you're asking for a change from what the dimensional requirements of the ordinance require. And so by statute, a property owner bears the burden of proving unnecessary hardship, as that term is used in section 6223 of the Wisconsin statutes. For an area variance, it's done by demonstrating that strict compliance with the zoning ordinance would unreasonably prevent the property owner from using the property owner's property for a permitted purpose, or would render conformity with the zoning ordinance unnecessarily burdensome. In all instances, a property owner bears the burden of proving that the unnecessary hardship is based on conditions unique to the property rather than considerations personal to the property owner, and that the unnecessary hardship was not created by the property owner. So, in other words, what you want to look at is the request, would compliance with the existing setback requirement be either, would it prevent him from using the property for a permitted purpose? Well, no, because it's being used now for a liquor store. But the other aspect of it is, would strict compliance be unnecessarily burdensome for them to comply? And again, so what you're looking at is the conditions particular to this property, its location, its the configuration of the property, the considerations in relationship to any geographic features, for example, the existing structure, the conditions of the neighborhood, and what you want to also consider is what is the purpose of having the rear yard setback in the first place. Again, the question, I think one of the initial questions is the size of the building, and so an appropriate question, for example, may be, is there a way to do it that would comply with the ordinance? And if not, why not? So, thank you.
Rick?
I guess one of my questions, and I guess you can address the question that the city attorney would like, and that's what type of hardship is this? one of my questions to the owner is though, the neighbor to the direct west of you, I tried to go over there like 2 or 3 times to talk to him, to see if they had a problem with it. Have you talked to that gentleman?
Yes,
And
first,
what was his response to you?
he's okay with it. I told him like we proposed, we're gonna have a fence and, the trees as well, so it's not gonna be, his privacy is gonna be, maintained. And he's a customer of ours and a good, friend as well. I mean, the last owner, he was a very good friend of mine, and we are also. We just took over in last March, so he's still, so he's okay with it.
You're saying you're the new owner?
Yes,
How long have you owned it?
we just took over in the March of this year. So,
Mark, if I could ask you a question, in regards to the entry and exit out of the liquor store, they're eliminating 2 entryways right on the corner. Does that benefit the city at all? From a safety standpoint?
Yeah, that's one of the things that you have to look at within the city code of ordinances. There's 5 points that you have to look at in order to look at a variance. One is the preservation of intent. Is it consistent with the purpose and intent of the regulations within the district? I think if you look at this property, it's a corner lot, and so the configuration of the building is such that if they had their address on Lunham, they would meet the requirements for the rear yard setback with a Lunham address, but they don't meet the requirements for the rear yard setback with a Packard address. So if you look at it, is it consistent with the regulations of the district? I think that you look at the alleyway, we currently allow residential properties, and most of the properties to the west are all residential. You can have an accessory building within 5 feet of the property line as an accessory structure, but when it's a business operation, it has to maintain a setback of 20 feet. So it's certainly, when you look at the preservation of the intent, there are other variances even within the neighboring or adjacent property owners which have closer setbacks than what is required by this property. When you look at exceptional circumstances, which is another condition of our zoning code, is there anything extraordinary? And I think that's one of the things that, Rick, that you just made a question about. They do have something that's extraordinary. They have 4 entrances and exits. There's 4 ingress and egress into this property, and it is a corner lot. So we have driveways that go in and out of the lot right on the corner. Within 10 feet of the corner, we have ingress and egress driveway access to this property, and then a mere 30 feet away, there's another driveway access. So what they're proposing and what they've discussed with city staff is eliminating 2 of those driveways. So they're gonna eliminate both of the driveways on the corners, which will make the corners safer for pedestrians, and it'll make it safer for vehicular traffic, because you won't have the conflict of people coming into a stop sign and having a driveway that's right there that they may have to contend with traffic coming out of this lot. So that is an exceptional circumstance. Then you also have to look at what Paul mentioned, is it an economic hardship or a self-imposed hardship? I think one of the things that they've mentioned is that they're attempting to add on to the building. Well, when you look at the economics of adding on 10 feet onto a 40-foot building versus adding the additional space, the cost per square foot is lower by adding a larger building than a smaller addition to the building. So therefore, it becomes an economic hardship if they don't have a variance to allow them to be within 10 feet of the alleyway, or it's actually 10 feet 5 inches, I think, from the alleyway is what they're requesting. Preservation of property rights, is it necessary to preserve the enjoyment of substantial property rights possessed by other properties in the district. If you look at the neighboring business property, which I think is zoned mixed use, that property does have a garage that's within 5 feet of the alleyway. So that property is consistent in the preservation of the rights for the neighboring property that they are allowed to have a setback of only 5 feet compared to the requirement of Packard Liquor of having a 20 feet. And then there's also the absence of detriment. Is this variance, shall it create a substantial detriment to any adjacent property owner? Again, I think it, based on what I've discussed, they're currently, with the 10-foot setback and an 18-foot alleyway, they're still going to be almost 30 feet from the neighboring property line to the west. So it certainly isn't a detriment to the neighboring property owner to reduce the setback to 10 feet. In other words, you're not bringing the principal structure to within 10 feet of the property line that might be a commercial use versus a residential use. They've also agreed to comply with city code. All city code indicates that on a commercial property versus a residential property, they have to have a 6-foot high privacy fence, and they have to have landscaping, which is part of the site plan as well. So I think it meets all of the 5 items within our code.
Okay, so that being said, seeing as though you've made this gentleman's argument for him,
Well, I'm just trying to go, because that's what, under a zoning variance, you have to look at the 5 items within.
I get it,
It can't
I
be,
get it.
it can't be an arbitrary decision.
I get it. But now that we can move forward, I do have a couple of questions. You said that you're going to make this a grocery store and not increase the size of the liquor store, correct?
It's an existing liquor store and grocery
Correct.
store.
It
is a grocery
I understand
store
that,
already.
right? Convenience store.
Yes,
Yeah.
and the
You're
addition,
just making it bigger.
yes, for groceries.
My question is, with making the building bigger, are you planning on having more than one employee
Yes,
in the building?
yes.
Because I know that
Right now is one employee.
right now it's one employee, and I think
And
that if you
there is
would
a staff
increase the
person.
size of that building, then it would be unsafe for more
Yes,
than,
no,
to only
we
have one
wouldn't
person.
need two people. We are planning to have 2 people at one
Minimum.
time, yes.
Okay.
Make a motion to grant the variance?
I second.
You would want to enunciate the reasons for that. I mean, again, with respect to the items that the city administrator enunciated, as far as the considerations. So that, for example, are you finding that it would be unduly burdensome to comply with it? Again, the point being that you want to make sure that you're consistent with what the code requires and what the statute requires.
If I could, does the zoning administrator have a recommendation for the committee?
My recommendation would be to grant the variance because it meets the 5 conditions within the city's code. And I think they've identified their economic hardship per the state statute.
You're referring to the conditions unique to the property rather than economic, I think, correct?
Yes.
Okay, thank you.
It's spelled out in the zoning code, the 5 conditions that I
The motion would be to grant the variance as it meets the 5 conditions in the city's zoning code.
Is that what we're looking for, Paul?
Yes, sir.
Second? Anybody, who seconded it?
Yes, John Cole did.
Okay, all those in favor? Aye. Those that are not?
With regard to the variance that's being granted, is there a time condition on it? I don't know if we have a projected build-out plan
Well,
or
we're at the mercy
timeframe.
of the schedule of the city. We still need to go in front of the architectural review board, the planning commission, prepare the construction documents, submit it to wait for the plan review and construction permit, so it's contingent upon the time that St. Francis allocates for this. We, we want to,
that's the
if
idea,
if
yes.
possible, yes, we would like to do it as soon as possible, yeah.
Thank you.
Can we amend this pending on the outcome with the city administrator and city, or I should say, city staff, to get,
You could, I mean, you can move to reconsider it and then make it, and then reconsider the motion and then make it just subject to, well, you can get the variance subject to it being approved by the architectural.
Aesthetic Control
Aesthetic
Board
Control
and the
Board.
Planning Commission.
But, you know, I mean, if they don't get that, they still, the variance doesn't do them any good anyway, so they, it doesn't supersede the other code
Right.
requirements. So, I mean, it's not necessary, but you, yes, you could.
okay, so how do we end this then if we're not,
I think you're fine the way you are right now.
okay? Thank
But they
you.
understand that they need to get
Thank
those.
you.
Thank you, thank you very much.
Okay, Ann?
Okay, and then, next is, the appeal, the determination of the St. Francis zoning administrator denying occupancy of payday loan agency and/or title loan agency use within B2 general business zoning at 2320 East Layton Avenue.
And I'm gonna assume you're here for payday loan?
Yes.
If you could state your name for the record, please.
Rodney Carter. I'm an attorney with Hush Blackwell, 511 North Broadway in Milwaukee.
Okay, Paul?
This is an appeal from the decision of the zoning administrator alleging error with respect to the determination concerning non-conforming use status. Just as you may know, the statute that empowers cities to grant zoning ordinances also exempts from their restrictions valid non-conforming uses. That was stated in the City of Lake Geneva versus Smuda by the Wisconsin Supreme Court back in 1977. The statute defines a non-conforming use as a use of land, a dwelling, or a building that existed lawfully before the current zoning ordinance was enacted or amended, but that does not conform with the use restrictions in the current ordinance. The same statute also goes on to explain that for non-conforming uses, the continued lawful use of a building, premises, structure, or fixture existing at the time of the adoption or amendment of a zoning ordinance may not be prohibited, although the use does not conform with the provisions of the ordinance. The non-conforming use may not be extended. The total structural repairs or alterations in such a non-conforming building, premises, structure, or fixture shall not, during its life, exceed 50% of the assessed value of the buildings, premises, structure, or fixture, unless permanently changed to conforming use. If the non-conforming use is discontinued for a period of 12 months, any future use of the building, premises, structure, or fixture shall conform to the ordinance. In City of Lake Geneva versus Smuda, the Wisconsin Supreme Court acknowledged a two-part test that was set forth in Walworth County versus Hartwell in 1974 case, under which the property owner was required to prove, one, a non-conforming use was in existence at the time the ordinance was passed, and two, the use of the property prior to the ordinance was so active and actual that it can be said the property owner acquired a vested interest in its continuance. A casual and occasional or accessory or incidental use does not create a vested interest. Applying the Smuda analysis here, the property owner would need to prove that there existed a valid nonconforming use before the effective date of the ordinance, and that the pre-ordinance use was itself lawful. So I think, so there is a presentation by both the property owner for consideration by the board this evening, as well as, I believe, the city administrator / zoning administrator is present. My recommendation would be to allow both parties to make their presentation to the board, asking questions of them with respect to their positions, and then subsequent to that, to deliberate with respect to whether or not the error has been demonstrated.
Do you have an NFL coin to flip, to who discusses first?
Well, the go first. So I think Carter would proceed with respect to his contention that the city zoning administrator / city administrator erred in his determination.
I got it.
And then go from there.
Remind me not to tell a joke to start a meeting.
Right.
Go ahead, sir.
Before I start, just so that I'm clear, Paul, are you representing
The board.
city or the board?
The board.
The board, okay.
Yes.
So good evening, everyone. We are counsel for QC Financial Services, Inc., doing business as USA Payday Loans. Taking you back on the history of this property, in 2002, USA Payday Loans began operations at this site. At the time in which the operations began, the site was zoned B2. And in the certificate of occupancy, which we included in your packets as Exhibit B, it is indicated that the type of business is, and I'm quoting directly from the certificate of occupancy, USA Payday Loans, Perrins Financial Institution, and then there's the phone number of the Payday Loans store. So on the face of your certificate of occupancy from 2002, it identified the business as Payday Loans, and it identified them as a financial institution. Back in 2002, your code placed this property in the B2 zone. And in 2002, the B2 zone provided that a permitted use included a bank, financial institution, broker, or pawnbroker. We would conclude, or we would assert, that clearly Payday Loans falls within the definition, the code definition at that time. Well, there wasn't a code definition, but it would meet the requirements of a financial institution. And I'll get to that definition in a minute, but certainly the village, by virtue of the name of this organization, 20 years ago, granted a certificate of occupancy approving a payday loan source. And I haven't heard or seen information from anyone who was here in 2002 that somehow the city was misled or it was misrepresented as to the nature of that operation. So after 2002, the business continues for 20 years without any indication that I've seen in the record before you that there was a problem with this business or with the services that it offered. Earlier this year, our client acquired USA Payday Loans. And in acquiring USA Payday Loans, they reached out to the city and they asked what steps were necessary to be a good corporate citizen and make sure that the city knew who indeed was operating and that there had been a change of ownership at that property. And it's important to note here, at no time was it ever represented to the city that there was an expansion or a change in the original use that had been going on there for the past 2 decades. The city responded to QC Financial's request by denying the application and saying that the code does not, and this is documented in the files and the record that we have submitted, that the city code doesn't allow payday loans or title loan agencies in any zone. It was then suggested that USA Payday Loans apply for a zoning change, and that zoning change went before the zoning administrator and it was denied. And then it went before the Plan Commission where it was also denied. So what I'd like to do is kind of walk through what we've submitted here. I feel as though, in some respects, and I'm a little curious to see if the argument will change tonight, that every time USA Payday Loans is advanced an argument, the position of the city administrator changes. And so we have to advance a new argument to quash the new position. But initially, what we had was, as I say, the 2002 occupancy permit. And then I think the next relevant document in terms of the timeline in the city's concession is the staff report that your city administrator gave to the Plan Commission, and that's the April 6, 2022 City of St. Francis staff report, where on page 2, the city concedes, and I'm quoting, "The existing use of 2320 Layton Avenue is USA Payday Loans, is a payday loan agency as a legal, non-conforming use." So we have that concession coming from the city administrator. But then he goes on to say that the continued use doesn't fit with the comprehensive plan. It isn't allowed under the current zoning code, which was amended in the last 2 decades, as you probably all know. And that it really isn't what the city would prefer to see in this parkway. And what I would submit to you is that those 3 standards that were articulated to the Plan Commission and on which the Plan Commission denied USA Payday Loans application, that's an example, a classic example, I think, of the city and city staff exercising their will of what they would like to see versus their judgment. And the law requires that the city exercise its that it not exercise its will, that it exercise its judgment. And the code provisions and the ongoing use demonstrate that nothing has changed here. You have what most people would call a grandfathered use that has not changed. And we had discussions with the city attorney and who in exchange communicated with the city administrator. I've never spoken directly with the city administrator on this issue, but USA Payday Loans has. And as part of those discussions, we submitted photos. We submitted photos of the signage that was here before our client acquired the business. We submitted paperwork and redacted applications to show that the type of transactions that were of concern to the city were being performed prior to this transaction. So we move from the actual Plan Commission application to some of my conversations that I had with Mr. Alexi. And at one point, well, let me back up. As part of the discussions that we had with staff, and once we identified that this use was a pre-existing use, the argument was made that somehow the use had expanded or changed, or that the website for our client indicated that there were services offered at this location that hadn't been offered before. And my response to the city was then, and it is to all of you now, is any services that weren't offered before are not being offered at this location. And it hasn't been clearly articulated to me what the nature of those services are, but we are not offering additional services. The next argument that we encountered was Attorney Alexi forwarding an email from the city administrator indicating that the property was zoned not B2 but B1, and that in B1 you couldn't have financial institutions, and therefore this was never allowed. So we dug through the code, presented evidence that indeed this was always a B2 zone and that B2 always allowed these types of uses. And then as we went on and exchanged emails, the city attorney even conceded that there was originally a payday loan usage here. We have an email from him that's attached as Exhibit I. It's an email from Attorney Alexi to me dated June 7th that indicates, as I understand it, and I'm quoting directly, the impetus behind the request to apply for a special use permit arises from the fact that the proposed Len Nation use is more expansive as to the financial services being offered beyond the original payday loan usage. So there was a concession that we had originally this payday loan usage. The other issue is that we were confronted with was that somehow back when the permit was issued that perhaps we misrepresented or the folks who operated the institution at that time misrepresented the use. And I guess what I would say is the certificate of occupancy is really clear that that was a financial institution, and that was something in 2002 that the city considered to be a financial institution. It noted it on the face of the occupancy permit, and I haven't seen or heard from anyone who was here in 2002 to tell us the contrary. So I think, you know, you're looking at a code provision that was in effect in 2002 that talks about a financial institution. It doesn't define financial institution, so in scratching my head and wondering what is a financial institution and does this use somehow fall within it, I looked up the definition today, and the definition of a financial institution is exactly what we're doing there now. Financial institution is businesses or a business that provides services as intermediaries for different types of financial, monetary transactions. And that's exactly what we're doing.
Can you explain the source of the definition, please?
Actually, that was Wikipedia.
Oh, okay, thank you.
So it's our position that this is a financial institution. To say otherwise, especially in light of 2 decades of permitted use, I think flies within the face of logic. I don't think it would withstand a review by a judge. And all that we are asking, and this was indicated in our application materials at several points in the application, if you look at them, that it is, as the application said, the same use that has been in place since 2002. The city has no basis to say that a new owner stepping in and not looking to change anything, not even the sign out front, is a basis to deny that use, that legal non-conforming use that back when this started, your own administrator acknowledged in a representation in the record to your plan commission was a legal non-conforming use. It's no basis to terminate it now. So we hope you do the right thing tonight, and we ask that the decision of the city administrator is reversed.
Paul?
Actually, I have a question for Mr. Carter. With regard to the certificate you said your client acquired the interest in the property earlier this year. Who did they acquire the interest from?
The original, I'm going to refer back to the,
Was it Jeffrey Silverman?
don't have a ready answer.
With regard to the, you indicated a concession, and you know, obviously, the part that wasn't in your brief was my understanding is, which you did read in the entirety of the email. I would you understand, you would agree that I was relating what my understanding of what the impetus was, rather than stating it as a matter of fact, correct?
You indicate, and this is where I'm questioning, Paul, quite honestly, who you're representing. You indicate
My
that the
understanding
impetus
is-
behind the request to apply for a special.
Okay,
use
hold,
permit-
hold, I'm gonna interrupt here. Right now, this seems like we're in a tailspin between two attorneys, and quite frankly, it's not English at this point any longer. My point is, if I could just ask a question, see if we can direct some of this. He had stated that it was a legal, non-conforming use. Paul, are we at the, I heard the term illegal, and if we can have that,
Well, I think
I mean, we need to have that definition also, I think, to move forward.
Well, correct. So a legal nonconforming use is one that was legal under the ordinance that was in place at the time that the use was commenced. So that's really the question. And so again, with respect to, you know, what was legal under, I think it was if I recall reading, it was a 1964 ordinance that was in effect as of the 2002 application. Is that your understanding, Mr. Carter?
Correct.
Okay, and so your understanding is that it referred to a financial institution, correct?
I can tell you what the 1960, that ordinance says. So in the code that was in effect at that time is, the code section at issue is section 239.13. It says Business District B2, sub 1. Uses, in the Business District B2, no building or premises shall be used, and no building shall hereinafter be erected or structurally altered unless otherwise provided in this ordinance, except for one or more of the following uses. And then it goes down and it says bank and financial institution, brokerage, and pawnbroker. And I could find nothing in the code that defined the terms bank, financial institution, brokerage, or pawnbroker.
Paul, you questioned the, where he got his definition of,
Well, the reason is that, so, I mean, as a matter of ordinance or statutory construction, you first look within the ordinance itself to see if it's defined, and here, I think there's no question that the 1964 ordinance did not define what constituted a financial institution for purposes of the code, and so from there, you would go to the common ordinary, you know, or you'd look to see, is there another meaning under the statute that's defined, that was defined as of that time? And I will represent, I looked in the 1963, 1964 statutes, I could not find a specific definition for financial institutions. The closest thing was small financial companies, I believe it was, under Chapter 218 of the 1963, 1964 Wisconsin statutes that would have been presumably in place at the time the 1964 code was adopted. So again, absent that, then you look to what is the common ordinary meaning of the term, and so that's why I was wondering what the proposed definition, what the source of it was. I mean, typically I would look at.
Webster's was a very broad definition that was like 3 words, an entity that provides financial services. It didn't really shed any light.
Mark, you had a question?
Can I
Yes,
give my
yes, sir?
brief?
Mm-hmm, yep.
Okay, so,
I think what we're hearing tonight is something that's evolved. You know, when we're dealing with zoning, we get a request. So as a zoning administrator, I get a request for occupancy. That's the first step to any new business that comes into the city. And so the request for occupancy came from a Dawn Burry, which was representing, QC Holdings, Inc., a separate company from QC Financial, and she submitted a occupancy permit that indicated that they were going to be doing financial services short-term loans. So my determination under the zoning code, in pulling up financial services short-term loans for B2 zoning is that it's a payday loan agency or a title loan agency within B2 zoning. And so I indicated to Dawn that that would require an application for rezoning, and she agreed to make that application for rezoning. That application for rezoning was submitted on March 7th, 2022. And in my determination, again, I didn't look at the 1964 zoning code. I was looking at the zoning code from 2004. And she had already agreed to submit it as a rezoning. She wasn't making a case that the property was legal, non-conforming, and that she had the right to use the property without rezoning. She submitted the rezoning application. So the rezoning application was submitted to the city on March 7th. It went to the St. Francis Planning Commission on April 27th, 2022, at which time the Planning Commission denied the rezoning of the property based on the comprehensive plan.
Excuse me, I'm gonna, if I may interrupt at that point, Mr. Chairman. There's been a bit of a misstatement a couple times now with regard to the Planning Commission's action. The Planning Commission
Recommended denial.
recommended denial.
Right, recommended
The
denial.
matter has been stayed before it came to the public hearing that was scheduled for the Common Council, and there's been no public hearing and no action by the Common Council at the request
Well,
of
and
the
I was going
petitioner.
to, if you'll just let me finish, that was going to be my next statement, because I'm trying to give you the history here. We're kind of blending two things together. So what's happened is because they submitted an application for rezoning, they're blending the application for rezoning now with the request for a variance and the discussions and emails thereof going back and forth between the city attorney, the city zoning administrator, and the issue with regard to the Planning Commission. So Paul is correct. It's a recommendation of a denial that goes to the Common Council. The Common Council, at that time, QC Financial, when the recommendation for the denial for rezoning at 2320 East Layton Avenue was recommended for denial, they hired the current attorney representing QC Financial. The attorney made the request to the Common Council indicating that they would like to have the Common Council take no action on the recommendation from the Planning Commission on the premise that they would like to bring an appeal to the Zoning Board of Appeals prior to the council taking action on any rezoning application. So under that premise, we did further investigation of not only the application, but going back into the 1964 zoning code. So in looking back at the 1964 zoning code, under which the application for a occupancy permit was granted to USA Payday Loans. It actually was granted to a Jeffrey Silverman doing business as USA Payday Loans. The determination, again, in looking back at whether something is legal at the time of 1964. So you have to really go back. Our zoning code, approved zoning code was 1964, and we revised our zoning code in 2004. So there's only been two revisions or two zoning codes that have been in place since the city was incorporated in 1953. So we have the 1964 adopted zoning code, and if you look at the 1964 adopted zoning code, the determination of looking at that 1964 zoning code in relationship to a 2002 occupancy permit that was granted under the premise that it was a financial institution in B2 zoning. And what my determination is that in fact that is an illegal non-conforming use within B2 zoning, and that's been consistent. I've been consistent throughout my determination that in order to have a payday loan agency or a title loan agency in B2 zoning, whether it's under the 2004 zoning code or now, when and the variance came up, and I did a full research of the 1964 zoning code, my determination is that the definition of a financial institution, and the attorney representing QC Financials admitted that there is no definition within the code for a financial institution. So then what, as a zoning administrator, what I look at, and Paul indicated if it's in the state statutes, if there's a definition, and couldn't find anything. So what I did is I looked at the 1964 Webster Dictionary definition of a financial institution at that time, and it indicates that it's a company that deals with money such as a bank, savings and loan, or credit union. Financial institutions, by definition, both accept deposits and provide loans. This is, again, in 1964, when our zoning code was adopted by the city of St. Francis. So as a business, USA Payday Loans neither accepts deposits, nor is a bank, a savings and loan, or a credit union by definition in Webster's Dictionary of 1964. Neither are they licensed as a bank, credit union, or savings and loan, or is their use of the property either a bank, a savings and loan, or a credit union. So when you look at payday loan, and you look at it in today's standard, and I think what he was indicating in Wikipedia is that's today's definition, because financial businesses have changed since 1964. If you look at Investopedia, they define payday loan as a type of short-term loan borrowing where a lender will extend high-interest credit based on income with a principal payment, typically a portion of the next paycheck. That is not something that would be in a definition for a financial institution. That type of loan would not be in a definition of a financial institution in 1964, because in 1964 there wasn't those types of loans. So what I'm contending is that, contrary to all the previous communications and emails, the determination of myself as the zoning administrator has been consistent in the determination that a payday loan agency or title loan agency use is not a permitted use at 2320 East Layton Avenue within B2 general business zoning. And even under further investigation of the city zoning code in reflection of the 1964 zoning code at the time of the adoption and issuance of the 2002 occupancy certificate, we cannot look at whether a business name says payday loan, because we don't determine zoning based on a business name or ownership of a property. We determine zoning based on its use. And so what I'm contending is that it's not a financial institution based on the 1964 definition of a financial institution, because there weren't short-term loans, high interest rate loans that were being issued by financial institutions in 1964 when our code was adopted. Therefore, it was never a legal use in the 1964 zoning code. Contrary to what I had indicated in the staff report again was assuming that they were requesting a rezoning, and I only looked at the 2004 zoning code at the time. I did not look at the 1964 zoning code. So once I made that determination, I now make the determination that it was never a legal use, even though a occupancy permit was issued for a financial institution. Under the definition of financial institution in 1964, a payday loan or a title loan agency would not have been a permitted use. Therefore, it does not have a legal status. And I'll use this as an example. If you have an R1 zoned property, it's a single-family home that we all live in here in St. Francis, and that is a permitted use in the zoning code. You're R1, you're defined as R1, it's a single-family home. If the city changes the zoning at a later date to a different zoning, you have a legal non-conforming use to continue to use that property as a single-family residential property. But in this case, it is not a legal use in 1964, so therefore, my determination is that this is an illegal non-conforming use within a B2 zoning, irregardless of whether an occupancy permit was issued for a financial institution, because we don't know what the circumstances behind that application were. We don't know what Jeffrey Silverman presented to then zoning administrator Craig Vettner to make a determination on whether that was going to be used as a financial institution. We don't even know if in the application they represented that they were going to be a financial institution where they were going to accept deposits and they were going to issue loans, and that it was going to be a branch bank of savings and loan or something else, because that application isn't there. We don't know. So the only thing we can go back to then is the definition of a financial institution in 1964, and I contend that that was not a legal use. That was not a legal use in 1964. So irregardless whether the city allowed it under that occupancy permit, again, we don't know what operations were happening within that occupancy permit, because there's nothing where we check on an annual basis, what are you doing under this occupancy permit once the occupancy permit is issued, unless we get a complaint from a resident or another business or a police officer. We don't do an investigation on that occupancy permit to make a determination whether they're in compliance with the 2002 occupancy permit. So what I'm asking from the Zoning Board of Appeals is to uphold my determination that this in fact is an illegal non-conforming use based on the definition of a financial institution in 1964.
Yes, sir.
I'd like to ask the zoning administrator, the gentleman brought up a point that I think everybody hears at one time or another, and that's the grandfather clause. Can you,
Well, you can't, and again, I think that what he's trying to indicate is that it's a legal use. It was a legal use because we issued an occupancy for a financial institution. What I'm saying is that it doesn't meet the definition of a financial institution in 1964. And so therefore, whether that occupancy permit was issued or not in 2002, what I'm contending is either the representation to then zoning administrator Craig Vettner was that this was a financial institution and therefore he issued an occupancy for a financial institution, or there was a mistake made that an occupancy permit was issued when there really should have been a rezoning in 2002 of the property to permit a payday loan agency or a title loan agency in B2 zoning. It is never, in B2 zoning, whether you look at the 1964 code or whether you look at the 2004 code, a payday loan agency or a title loan agency has never been a permitted use.
Well,
If I may, Mr. Chairman,
hang on, Paul, because I have a question for you. I don't know if following a 1964 law, I mean, things change. In 1964, I was looking forward to buying my first comb. And things change, and we don't have any use for that. So my only question, Paul, is in the 2004 rezoning, is it your opinion that would be an illegal use? And I'm questioning the grandfather thing because of the fact that would be he would be a new business using the same name, but he was a new business. So are we then obligated to follow the 2004 B2 rezoning?
well, so he would have had, if the use was legal in 2002, then regardless of what the 2004 code said, it would have had legal nonconforming status. If it was illegal and it was then prohibited under the 2004 code, then then you don't get the grandfathered rights, okay? The law has been, in Wisconsin, is that there's no rights vested or otherwise in an unlawful use, and that's.
So
been the
I
case
I guess what I'm asking you, Paul, is in your legal opinion, because that's what we pay you for, is this a illegal non-using, conforming or use, or is this a legal, non-conforming use?
With all due respect, it's a question that the board has to decide based on the evidence that's before it. In my opinion, I think there's questions of fact that, you know, that if known, would certainly make this a lot easier. What we don't know is, I think the city administrator pointed out, we don't know what the application for the occupancy permit in 2002 said. We do know on its face, it said it was payday loans, and that we do know that it said it was, that the occupancy permit was granted for a financial institution. So there's several possibilities that come to light there. Either the zoning administrator at the time erred, or that there was a considered opinion made and determined that the payday loan fit in within what the city recognized to be a financial institution. The third possibility is that that the application, which we don't have, said that they would have qualified as a traditional financial institution. I think there are multiple potential definitions, including under Black's, a non-depository financial institution. So we start to, you know, we kind of revolve around the question of, you know, how thin do you want to slice the bologna, if you will, as far as what constituted a financial institution for purposes of the 1964 code. If you look specifically at what Attorney Carter read as far as those items in there, those would be the types of, you know, the specific items that were permitted. Within those, again, you have to kind of glean as far as what was intended as far as when they referenced a financial institution, what did they intend to include? I think the petitioner's argument is that, you know, the indicia is that by the fact that the zoning administrator in 2002 granted the permit, that he concluded that it was there. The current city zoning administrator's position is that if I go back and look at what the definition was, that wasn't there. There were some types of small types of business loans or, you know, personal loans that were done in 1964, but they had a little different terminology under Chapter 218 of the Wisconsin statutes. So, I mean, there is you know, the administrator's correct. I mean, normally we wouldn't go in and do any kind of investigation. What exactly are you doing under your occupancy permit? With the exception of, you know, what may be caught by the fire inspectors when they go in periodically, or if there's a building permit that's requested. Those would be the types of things. Here, there was a change, you know, again, the original occupancy permit was granted to, I think, Mr. Silverman, doing business as, looks like the payday loans. It's not clear whether or not he continued or if it was somehow became another entity, which, you know, may have, if that was the case, then that should have triggered a request for a new occupancy permit. Certainly, you know, there's no reason to doubt that the current owners of the business were trying to be above board and come before the city and make sure they got whatever permit that they needed. You know, again, so just to be clear, the certificate of occupancy permit ordinance for the city requires essentially three different things that the zoning administrator look at. One is, do they meet the zoning requirements? Two, do they meet the building code requirements? And three, do they meet the health department requirements? So where we, you know, the question mark is, did they meet that requirement with regard to the zoning? If they are legal non-conforming use, if you find that they are legal non-conforming use, well, then that's one thing. Just because the business is being sold, they don't lose if they were a legal non-conforming use, they don't lose that right just because it gets sold to someone else. It's the use, the continuous use of the property that determines, if it was legal, that would determine their status. So I can see both arguments, quite honestly. But that's why y'all make the big money and get to make the tough decisions as far as whether or not the, you know,
Mr. Chair.
they meet the requirements. But it is the, you know, again, as I read the law, it's the petitioner's obligation to, you know, to demonstrate the legal non-conforming status.
Did this go through the zoning board back in 2002?
There's nothing that we can see that
It
was the
didn't?
case, as I
Okay,
understand
I
it.
was just wondering.
So I just want to add that in 2002, the prevailing code was adopted in 1964. So that's the code that in order to make a contention that it was a legal use in 2002, we have to go back and look at the 1964 code and not zoning code and not the zoning code that was adopted in 2004.
The record, we disagree.
The only question I have in this whole thing is, and I don't disagree with you that you've been there for a long time, doing business for a long time, or they've been there for a long time, doing business for a long time, without any incidents. My question comes in when we're talking about legal or illegal use. I don't know if we can grant illegal use if it's illegal. But I do have an issue with a 1964 law because there was, as they both stated, they didn't have these types of businesses around in 1964. So I don't know if that's his fault that that type of business wasn't around in 1964. But I mean, for me, that clouds it.
So
And if they're saying that we can't, if they're saying that we cannot, if they're saying, if Paul, if I'm correct in what Paul is saying, and Paul, correct me if I'm wrong, we cannot base our decision on the fact that it's a new owner. We have to base our fact on the point of that what it was operating under in 2002, which would have been 2004, correct?
Correct. I mean, you look at what was there as of the 2002 code, you know, the code that was in existence as of 2002, at that time that they came in, were they illegal? Were they was it a legal use of the property? I assume, again, I'm assuming that we're assuming for purposes of our discussion this evening, it seems that they were operating as a payday loan type of issue, or entity rather.
So I think, though, there's been, that by focusing on this argument that somehow, because in 1964 this wasn't envisioned, it wouldn't have been allowed in 2002, is pure speculation. And it flies in the face of interpretation of your ordinances. The plain meaning of this is, what's a financial institution? You had a representative of this city make a decision to issue a certificate of occupancy in 2002, which on its face was issued to USA Payday Loans Financial Institution. You cannot, at this point in time, turn around because new staff comes in without any evidence. There's nothing from the city's records. There's no evidence that any historical people were talked to who were back here in 2002 and claimed that, well, the 1964 statutes wouldn't have allowed this because these businesses weren't in existence. If that's the argument, I guess then, and if we go to circuit court and we can show that there was some type of similar use in 1964, that somehow the federal government or the state regulated these types of financial institutions, we lose. Or you lose. We win. Right here, what you have, and you experience it all the time, staff makes policy decisions on ordinances and how they work and what's allowed and what isn't. In 2002, you had someone who we haven't heard from in this dispute issue an occupancy permit for a payday loan institution that they said was a financial institution. You then have the matter advance, and your city administrator, because it doesn't fit with the current code and it doesn't fit with the master plan, say you've got to file for a rezoning. But he hasn't explained how your official minutes of your plan commission, which were approved by your plan commission, reflect the fact that at that meeting he represented it was a legal non-conforming use. Now he said, well, that's not really what I meant. Sort of like when he advanced the argument that this property was zoned B1 and it wouldn't be allowed. The 1964 reading of that code is a loser argument, and I'm telling you now, if you rely on that to deny us tonight, we will appeal to circuit court. And I like to be on that side of the argument, having to refute it, because it's gonna be easy to do. Thank you.
I make a motion to uphold the decision of the city zoning administrator. Second.
You would need to enunciate the reasons for your motion, for the record, so that,
Based on all the discussions,
I mean, is there something in particular as far as the facts or the arguments that you're making your motion on? Again, just so that it's clear, because, again, they do have the right to appeal the decision, and so.
it's based on a 1964 ordinance, based on a 1964 definition. Not based on a 2022 definition of what a financial institution is. If you're gonna use that ordinance for the, as your argument, you have to use all the data that you had in 1964. You can't just go surf the internet and bring everything in that agrees with what you want.
Can I get clarification?
Sure.
He wants to uphold the zoning administrator's decision?
Yes.
Yeah, that was my understanding of the motion.
That'd be Mark's, your decision.
Anybody else further discussion? Okay, I guess, who made the motion then for the,
Moved by Rich Adamczewski, seconded by Dennis Bessler to uphold the zoning administrator's decision.
all those in favor? Aye.
Aye.
All those disapprove?
Me, I disapprove.
We got one
Dissent.
dissent.
Here, this is part of it.
Those who wish to adjourn?
Second.
Those do not? We're out of here.